Any mention?
May I have the lordship?
Yes.
My lord, regarding the item number 7 and 8, matters pertain to the benefit of fifth pay commission, my lord. The similar issue is pending before the Supreme Court, my lord. It was last listed on 13/5/2026, and Honorable Supreme Court has fixed this matter on 208 to 2026, my lord. So this matter may be adjourned for 4 weeks, my lord.
You there? On Mr. B. Kumar, counsel for the. Yes?
Your Lordship, in fact, 7 and 11 are connected, Your Lordship, not 8.
Not,
I'm
not
sorry,
8.
my lord.
7 and 11.
I'm sorry,
Your
my
Lordship.
lord.
7, 11.
7 and 11, my lord.
On made by Mr. B. Kumar, learned counsel for the petitioner. Matter is adjourned for 4 weeks on the ground that similar matter are pending adjudication before the Supreme Court. 4 weeks.
My lord. Deeply, lordship.
Lord, my lord, I have already made a mention for urgent listing of a matter before the Honorable Chief Justice, and she has allowed and sent the matter here, my lord, to be heard. So,
Your Lordship, I've made a similar prayer as well,
same connected matter.
connected to the matter.
Connected?
Connected matter.
Okay.
Let's item number 1.
Please, Your Lordship. Well, 3 FIRs were filed against me, my lord. 3 FIRs were arising out of the same transaction. So, my lord, I approached the court, this honorable court, for clubbing of the 3 FIRs. Now, those 3 FIRs have already been clubbed together. Wide order dated, if I'll take my lord to page 32. Page 32 of my petition, my lords. 3 police station cases have been clubbed together. I will just read para 3. In view of the above stated, it is made clear that this court has not gone into any other relief sought for by the petitioner and as such restricts itself to the relief pressed for by the petitioner. Learned PP fairly on instructions states that all the 3 cases which are registered out of the common Facebook post and identical allegations, she states that the case registered with Sonsak Police Station and Fulbari Police Station will be clubbed with Araimail Police Station, which was registered first in the point of time and will be investigated together, statement accepted. Now, my lord, when all the 3 FIRs have been clubbed together, my lord, initially, my lord, while the FIR was lodged, my lord, I was undergoing treatment at Guwahati. I'm still undergoing treatment at Guwahati. So, my lord, I am anticipating arrest in connection with Araimail PS case, my lord, which has been clubbed together with the Sonsak as well as the Fulbari PS case. Now, my lord, a number of sections, my lord, if lordship, I'll just... Interestingly, my lord, in all these cases, my lord, the maximum punishment is less than 7 years. So, my lord, the question of otherwise automatic arrest would not come, and I would not have come before this honorable court also. But the fact that, my lord, 2 co-accused have already been arrested, and in fact, they have already been granted bail. In fact, one of the accused has been granted bail by this honorable court, default bail, because charge sheet was not filed within the mandatory period of time. So, my lord, taking into consideration the fact that 2 other accused persons were arrested, even though automatic arrest may not be allowed as per law, and notice should go, my lord, I am apprehending arrest. My lord, I am just making a prayer for some interim protection. In the meantime, my lord, a report may be called for, my lord. How the offences have been clubbed together and what case has been registered, which sections have been added, my lord.
Charge sheet has been filed?
No, charge sheet has not been filed. So that's why, my lord, on the basis of charge sheet not being filed, the other one accused person.
Okay.
No,
you have not been arrested, so
I have not been arrested.
Question of default bail has
my lord, does not arise. My only ground of moving bail is because, my lord, I am undergoing treatment at Guwahati. In fact, my lord, I was myself assaulted and I have also filed an FIR. But I will not go into that aspect as of now. I am only praying that, my lord, in connection with...
Should I produce
Let me
the CD?
have the case diary, Your Lordship.
When?
First week of June.
Lordship,
First week of June, because, my lord, we are having holidays next week.
Lordship, because next week will be holiday, then it will come in the first week of June, Your Lord.
Any date, 1st week of June, Your Lordship.
4th.
Lordship.
Heard Mr. K.C.S. Gautam and counsel for the applicant who has submitted that this application has been filed with a prayer for grant of anticipatory bail in connection with Arrival PS case number 19 of 26 under section the applicant being apprehensive of arrest in connection with such case. Mr. Andy Shulai Leonard AG appearing for the state respondents, appearing for all the respondents, has submitted that the case diary may be called for. Accordingly, the case diary of the Archival Data hereby called for to be produced on the next date fixed. In the meantime, as prayed for, interim bail is granted to the applicant with a direction that he shall appear before the IO as and when required, that he shall not abscond or tamper with evidence and witnesses. This is matter on 4th.
Oblige, Your Lordship.
Much obliged.
Item number 2.
Please.
May it please Lordship, this is an appeal arising out of the impugned judgment dated 15 April 2026, as well as the impugned order on sentence dated 22nd April 2026, passed in Sessions Case number 7 of 2023 by the Court of the Learned Sessions Judge Boy District at Nongpor. Your Lordship, in the instant case, the Learned Court below, without considering the evidence on record in its proper perspective and with a preconceived notion, had convicted and sentenced the appellant, which is yes, Lordship, which is required to be examined by this honorable court. The Learned Court below must misconstrue the provision of law by not accepting the defense evidence. Resultantly, there was conviction and sentence. The appellant was convicted under sections 307 and 323 of the Indian Penal Code and was sentenced to 5 years rigorous imprisonment for the offence under section 307 and a simple imprisonment of 6 months for the offence under section 323, and both sentences are to run concurrently. The appellant herein had been in judicial custody since his arrest on 2nd July 2022 till the date of passing the order on sentence, which was a total of 1391 days in judicial custody. So considering the date of arrest till date, the appellant had already served a period of 1416 days, which is approximately 3 years, 10 months and 15 days. The Learned Court below had considered the period undergone in judicial custody by the appellant as a set-off period. Therefore, the remaining sentence is approximately 1 year, 1 month, and 15 days, Lordship. Therefore, the appellant herein prays before this Honorable Court for suspension of sentence till the date of hearing of this instant appeal, Lordship, and the appellant will abide by the terms and conditions to be imposed by this Honorable Court for the purpose of suspension of sentence.
May it please your Lordship, if this matter may be listed for admission hearing, and there are certain points I would like to raise with regard to the evidence. In my humble submission, Lordship, the chain of circumstantial evidence in this case is absolutely complete. There's a lot of corroborative evidence to show that beyond a reasonable doubt that the accused actually committed the crime in question.
Matter will be heard.
Please, Lordship.
But as far as suspension of sentence is concerned, this will be taken up on the next date when the...
Please, Lordship, I wish to argue against suspension of sentence.
Appeal is to be admitted. Records are to be called for.
Yes, Lordship.
As and when the record comes, then have you filed a separate application for
suspension? Yes, Lordship. Yeah,
we'll take it up. So, admitted, heard. No? Appeal.
Grateful, Lordship.
Item number 6.
The record file affidavit here, my lord. They're still awaiting complete instruction. I'm praying for some maybe 2 weeks time, my lord. It's a freezing of the bank account by DC.
That interim order is still.
Yes,
the interim order is there, but my lord, I have got the copy of that how they have complied it. It is only with respect to few people. That is the Jha family. Whereas if I had pointed some 670 people's bank accounts were frozen, and debit defreeze, my lord, is a...
But are you appearing for all those people?
No, my lord, I am not appearing, but I am just pointing out, my lord, I must point out, because all these bank accounts came to be frozen in compliance to the judgment order dated 13th of February 2025, where the university is there. So everyone who has transacted with the university, my lord, his accounts have been frozen. That order, my lord, is a violation of Article 21. That is my only grouse here. Even though they have, my lord, they have given us that order defreezing only the bank accounts of the Jha family who are the petitioners here. But with regard to the other, my lord, more than 670 people, no defreezing order is passed. That order is ex officio illegal.
That may be the case. But if they are not before this court, then what do?
But then everyone, all over the country, they are all over the country. Poor people are also there. Panwala is also there.
Panwala I couldn't find.
Yes, the Panwala is also there. I can point out the person who has supplied cement to me, my lord, 3 stacks of, my lord, the cement. His account has also been frozen.
Yes, Dr. Musika, you look into this.
Well, actually, we asked for instruction because we are also quite confused looking at this order, on what basis the order has been issued, and the reply they've given is like we are ourselves not very satisfied. So we asked them, please give a complete instruction. 2 weeks time, madam.
Just check and see.
We will check it, madam.
Otherwise,
if there's nothing, madam, of course this order has to go, madam.
You can't expect a Panwala to survive with his accounts freeze. Dr. Musika, senior advocate, has appearing for the state respondent, has sought for time. So has sought for some more time, has once again sought for some more time to file a counter. Accordingly, as paid for, same as allowed, this is matter of 3 weeks. I'm not passing order as far as that.
But I will just point out, Manoj, because it is in compliance to the judgment passed by the Supreme Court in a CMJ matter, and under that, I couldn't locate a para or a direction or a finding by the Supreme Court asking some entity, Manoj, to freeze the accounts of everyone.
Okay. We also couldn't locate, Manoj. That's why we asked, like, on what basis you have done that.
Okay, so we'll look into it.
Item number 8.
Deep.
Please, your Lordship. Lordship, in items number 8 and 9, I appear for respondents number 6 and 7. I filed my affidavits, madam.
Lordship, this 8, 9, 10, these are packed together.
8, 9, and 10.
8, 9, 10. 10 is the managing committee. 8 and 9, these are appointment of the private respondent have been challenged.
So the matter has to be heard then. They have filed their.
Lordship, yes. we have, just today only we received a copy of it.
But is there any rejoinder to be filed?
The submissions have been made, my lord, now. Managing committee, you are a
Former President and Secretary.
See, I think they have filed this counter having been denied, on an earlier occasion.
It was recalled, my lord. The orders were recalled, and thereafter we have.
So it's up to the petitioner whether you wish to file rejoinder or we'll proceed with the.
You can proceed.
Proceed. Mr. Direct Counsel for the respondent number
6 and 7.
6 and 7.
In items 8 and 9. I'm only in items number 8 and 9.
8 and 9?
Yes, ma'am.
What 8 and 9? I submitted that the counter affidavit on behalf of such respondent has been filed. Next. Dr. Muzika, Direct Counsel, Direct Senior Counsel for the petitioner, has submitted that no rejoinder will be filed against such counter affidavit. Accordingly, as prayed for the parties, matter to be finally heard. This is the after 3 weeks.
Apply a lot.
The question thought this after 3 weeks.
Come together.
Item number 12.
This is a part of the matter. Please fix for my reply. Submission from the respondent side, all of them is concluded.
But as far as respondent number 4 is concerned, I'm here to make a submission.
Or you have.
No, other respondents have already made their submissions. I'm to make this submission. My lord, on the facts of the case,
yes.
My lord, through and through, the yes, my lord, through and through, my lord, the petitioner has been canvassing his case, stating that he is the senior most, my lord. Now, that claim is incorrect, my lord.
Yes. You are respondent 4.
I am respondent 4, my lord. So, my lord, if I am allowed to draw my lord's attention to page 23, my lord, of the writ petition.
Yes.
So, my lord, the order says, if I am allowed to read, my lord.
Yes.
Shri Rikrek C.H. Momin, on successful completion of his 1-year probation period on the 6th June 2005, he is hereby appointed as an assistant manager in the office of Meghalaya Industrial Development Corporation Limited in scale of so and so with effect from 1st June 2005, my lord. So this is the letter of his appointment. Now, my lord, now thereafter I take my lord to the next office order, my lord, which is at the next page. So this is the recommendation of the DPC. Sorry, my lord, DPC. So on the recommendation of the DPC, the following assistant managers. So these are the following assistant managers, all of them, including me, my lord. My name is at serial number 2. So all these people have been at the same point of time recommended, my lord, by the same authority at the same date, my lord, 7 March 2012. Now again, I draw my lord's attention to page 47 and 60, my lord, of the writ petition.
Yes.
So, my lord, will kindly see there is a chart which is given.
Yes.
So, my lord, serial number 2 3 and 4. These are more relevant, my lord.
Yes.
So, my lord, the date of appointment, my lord will kindly see, is 1/6/2004, which is column number 3, my lord, 1, 2, 3.
Yes.
Date of appointment of the petitioner is also 1/6/2004, as well as at serial number 3, because these are the 3 names which were recommended, my lord, for the post of MD. So here also, my lord, will kindly see it's 1/6/2004. Subsequently, my lord, they were under probation, and then thereafter, ultimately their appointment was granted as assistant manager, my lord. Although it is written as promotion, but that is incorrect, my lord. It is the date where they were appointed as assistant manager, my lord. So my lord will kindly see the date of appointment, my lord. It is 1/6/2005. 1/6/2005. So serial number 2, 3, 4. In fact, my name is on the top, my lord. At number 2. That will be at, my lord, 1, 2, 3, 4, 5, 6. These 6 columns, my lord. It is shown as date of promotion, but this is the date when we were appointed as assistant managers, my lord.
Yes.
So my lord will kindly see 1/6/2005. That is from serial number.
Same date.
Yes, my lord. Serial number 2 to 4, same date, my lord will kindly see.
Yes.
Subsequent promotions also, my lord will kindly see the next.
Yes.
It is at 1/3/2012. 1/3/2012. 1/3/2012.
Okay.
Then again, my lord, so all the orders, my lord will kindly see, they have the same date. The next, it is the date of promotion to AGM, Assistant General Manager. That is also 1/3/2017, 1/3/2017, 1/3/2017. Subsequently, my lord, the post of the General Manager, that is also, my lord will kindly see. So all the dates are the same. Same date of appointment, same date of joining. What is the basis of my friend canvassing the case, stating that he is the senior most? Now, even assuming, my lord, just for the sake of argument, even assuming that he is the senior most, my friend has not been able to show any law or any instruction whereby it says that the senior most person will have to be appointed. Now, whether my friend has any vested right to be appointed, in my respectful submission, it cannot be the case, my lord. He may have a right to be considered, but appointment, whether it is a vested right or not, he does not have a vested right. Now, as long as, so according to him, as long as he is appointed, absolutely everything is in order. Just because he is not appointed, then nothing is in order. That is incorrect, my lord. Now, when all the names were forwarded.
You see, now you have to explain to this court.
Yes,
see,
my lord.
What was canvassed by the petitioner,
yes,
is the date of appointment vis-a-vis the date of joining. So,
my lord, in that circumstance, my lord, I will endorse to the submissions which is made by the MIDC as well as the Government Council, my lord, that it will have to be, the appointment will have to be counted from the date of actual joining of the service, not on the date of the probation, my lord. That is also the statement which is made in the affidavit filed by the MIDC, filed by the government as a clear stand. Why? Because it is already laid down, my lord, laid down in the rules of the MIDC, my lord. In the absence, my friend had relied on Supreme Court judgment, but there, my lord, when the rules don't specify, but here is a case where the rules clearly specified, my lord. Now, second aspect, my lord, is when these names were forwarded, these were never challenged by by the petitioner for that matter, because if you had any objection with that, you should have challenged it then and there. You cannot cry foul after the decision has been taken or rendered by the government. Now the government in their, or the authorities in their wisdom, they have decided, my lord. Whether do I have the right to challenge that? According to me, I do not have the right. And once the list, you are very well aware that these are the 3 names which have been forwarded. Now it is not a case that none of them were holding this similar post. They are all in the similar post. That the petitioner was very well aware, my lord. But in spite of them, he never challenged that. Subsequently, whether you can challenge it, according to me, my lord, he is barred by estoppel to challenge it. Having not challenged this fact at the initial stage when the names are forwarded, because subsequently he cannot challenge it, my lord. Now, my lord, if I take my lord to my affidavit also. That was filed by respondent number 4, my lords. Which is filed by me. My lord has got
24/6.
My lord, it was filed on. Yes, my lord. Yes, correct, my lord. Now, page 3, para 10, my lord.
Yes.
If I am allowed to read, my lord.
Yes.
That in response to the averments made in para 2 and 3 of the writ petition, the answering deponent, while denying the contentions of the petitioner false and baseless, states that the petitioner is not the senior most, because his whole case, my lord, it fails there. Because he has been canvassing his whole case, stating that he is the senior most. So, if I allowed to read, my lord, states that the petitioner is not the senior most as averred by him. In this regard, it may be stated the petitioner and the answering deponent respondent number 4 herein have been appointed on the same day in as much as all the corresponding promotions, upgradations, etc. from time to time have been granted on the same day. As the reference, the deponent humbly draws attention to this honorable court to letter number so and so dated 7/3/2012. So I have referred to this annexure 1, my lord, which is page 24 of the writ petition, wherein it can be seen that on the recommendation of the DPC, the petitioner along with the deponent has been promoted to the post of managers in the corporation with effect from 1/3/2012, and therefore the contention of the petitioner being the senior most in the department is totally false and baseless. Other than that also, my lord, now these lists have been and these promotions have been taking place for over a period of time. Now the petitioner has never objected to any of this. Right from the time when the appointment started, there was never a challenge saying that I am the senior most. There's not a single whisper, there's not a single letter to the department saying that he has objections to this list because he is the senior most. So his appointment should be having a different date compared to that of the petitioners. So this is not one. There are subsequent, my lord, all the steps. He has never objected to any of them. Subsequently, at the fag end, you come and object that this person could not have been appointed to the post of MD. Why? Because he is not the senior most. Whereas you have never canvassed this case earlier. You are stopped now. How can you canvass this case at this moment? If that was the case, even right at the inception when you join the service, let's say, let's take that situation where he joined, say about a week ahead in the post of probation, under the probation, my lord. So then and there, when the appointment order was issued, he should have objected at that point. He never objected. So subsequently, matters and settled, my lord. He cannot raise at this fag end. Next thing, my lord, where is the law which says, my lord, where is the law which says, my friend has not been able to show, where it says the senior most person will have to be appointed? Where is the law? Where is the rule? There is nothing in the rule. The discretion is with the government. To that effect, my lord, if I am allowed to draw my lord's attention to para 11.
No, see, Mr. Bhattacharya.
Yes, my lord.
When the DPC was constituted,
yes,
was there any sort of a guidelines or term of reference as far as the procedure to be adopted? Whether it should be
procedure will have to be
by way of seniority come merit or merit come seniority.
My lord, my respectful submission, my lord.
But is there any such
provisions will have to follow the MIDC rules, my lord. It cannot be a different rule.
Where is the constitution of the DPC?
My lord, that is covered in Rule 9, my lord. My lord, it is included in the petition itself. Page 7, my lord.
Page 7?
Yes. Writ petition. My lord, here of course the actual is at page 39, my lord.
Page 39?
Yes. 39 of the annexure, my lord.
You see,
it's the same thing. It's a direct quote of promotion, my lord. All promotions at the managerial level should be based on the appraisal performance of the incumbent as per norms adopted by the corporation. All promotions at the managerial level and other levels shall be based on appraisal performance of the incumbent, like efficiency, capability, past records and education qualification. So this is also part, my lord. Of course, I have an additional qualification also. The management is also to conduct written departmental tests and personnel interviews for promotions of staff up to assistant general manager level. That is the highest, that is the level, my lord.
no, this is there, I don't know whether something can be made out from here, whether this pertains only to managerial level and not the post of MD, kind of.
My lord, post of MD is not a promotional post. That is a clear thing. It ends there.
So it's not promotional.
It is not a promotional post. My lord, that is why I wanted to draw.
This rule will not cover them.
No. That is why, my lord, I wanted to draw my lord's attention to para 11, my lord. Para 11 of my affidavit, my lord. My lord, before that, my lord, if I may draw my lord's attention, my apologies, my lord. Page 40 of the writ petition, before I come to my my affidavit, my lord. It is at page 40, my lord, 1002.
Yes.
This is very clear, my lord, regarding seniority. An employee confirmed in the corporation service shall rank for seniority in his grade according to his date of joining. That is in the post, my lord. And an employee on probation according to the date of his joining the post. So that finishes the whole thing, my lord.
Rule 10.2.
10.2. It is very clear, my lord. This is at page 40 of the writ petition. I'll read it again, my lord.
Yes.
An employee confirmed in the corporation service shall rank for seniority in his grade according to his date of joining. That is in the post, my lord. But as far as probation is concerned, it is very clear. And an employee on probation according to the date of his joining the post. So we joined the post of assistant manager on 1/6/2005. and the appointment is with effect from yes 1/6/2005, my lord. So we are all together same. Now besides that, my lord, and why it is not a promotional post, my lord will kindly see the whole process of appointment is totally different. Names are forwarded, government has, your name was also forwarded. It is not a case that only my name has been forwarded. A, B, C, 3 names were forwarded. So naturally government will in its own discretion will decide who is to head as the MD or not. In my humble and respectful submission, you have no right to challenge the same. As long as your name is forwarded, it is not a case that your name was never forwarded. Three officers occupying senior most post, all their names have been referred. It is not a question of violation of principle justice, violation of principles of natural justice. It is not a case also. Even that is not a case. Because your name was forwarded at the same time. It is the discussion of the wisdom of the government. Do I have the right to challenge question the wisdom of the government? Equality. There is no such violation of the principles of equality, equity. Your name is equally forwarded. So is mine, so is another person's, 3 persons' name. So my lord, if I am allowed to draw my lord's attention to my affidavit, my lord, para 11, page 6 and 14. Sorry, my lord, page 6, my lord, para 11.
Yes.
If I am allowed to read, my lord.
Yes.
That in response to the averments made in para 4 of the writ petition, the answering deponent, while denying the contentions of the petitioner as false and baseless, reiterates what has already been stated in para 10 of this affidavit in opposition. The allegation of the petitioner that he has been superseded by respondent number 4 is false and without any basis. In this regard, it may be stated that the question of supersession as alleged does not arise, as the petitioner is not the senior most as ever. Further, there is also no such fixed convention as stated by the petitioner. Now, my lord, another limb of argument of the petitioner is that there has been a convention that whenever someone is appointed from the MIDC as an MD, the senior most is appointed. Now, whether convention can substitute law, my lord, substitute rules, it cannot, in my humble and respectful submission. So, my lord, I'll draw my lord's attention to the list, which is table A, page 7. So, my lord will kindly see, various people, anyone can be appointed. So, my lord, in serial number 1, my lord will kindly see, she S.B. Guru, Director of Industries. Now, at that point of time, there were many senior GMs in the corporation. However, government opted to appoint the Director of Industries as MD MIDC. The government can appoint anyone from anywhere. It is because it is a different post. It is not a promotional post. So even an outsider can be appointed as an MD of the corporation. Second appointment, my lord will kindly see J.R. Mitho, officer from MIDC. Then my lord will kindly see T.K. Chakraborty, that is also Director of Industries. At that point of also several senior managers were there in the MIDC, my lord, but the government decided that no, will appoint so and so person as the Director MIDC. MD, my lord. Subsequently, Sri A. Shom IAS, he is also CNS Industries. So my lord will kindly see. So most of the appointments are from all sorts of sources. You have people from Director of Industries, then we have people from Industries Department. Why? Because this is not a promotional post. So naturally their names have been forwarded to the government at that point of time. Now government in their wisdom might have thought.
That I think that is an admitted position.
Yes.
See, that appointment to the post of MD can be from 2 streams.
Yes.
So I think petitioner is not disputing that.
So my lord, even seniority, Even his claim of seniority goes. Now, at this stage, even at this stage, at a later stage, even if it is a question of supersession, as he is claiming, that cannot be claimed now. Because this list have been right from the time we were appointed. Time to time our appointments have been made on the same date. All of us, 3 of us have been appointed on the same date. At that relevant point of time, you never raise this question of supersession. Assuming that you are 7 days senior to me, even assuming, my lord, just for argument's sake, though not admitting, then at the very instance, the first time when the appointment was made to the post of assistant manager, that is the time period you should have raised your objection saying that this is supersession. They are not equal to me. Their appointment should come later. You have never raised that. So your opportunity goes then and there. After 20 years of service, 30 years of service, you cannot raise this question. Secondly, even in case of seniority, it clearly says that Rule 10 is absolutely clear, my lord. It says from the date of joining. If you are a probationer, then seniority will be counted on the date you join the service. We joined as assistant managers on 1/6/2005, my lord. That is the day we joined the service, all the 3. So this supersession claim cannot be made at this juncture. So first, we don't have any rules to show that post of MD is a promotional post. Secondly, as far as seniority is concerned, there is nothing to show that the petitioner is the senior most. Thirdly, the post of the conventions cannot substitute any rule. Just merely because there is a convention does not mean that you have absolute right. Now, the thing is that having not objected, this is included in the petition. Is it included in the petition? My lord, this is as per the memorandum of association, my lord. You have an extra copy. My lord will kindly bear with me. Have you included the memorandum of association also? Lord, this is the MIDC rules, my lord, page 62. I wanted to draw my lord's attention. Sorry, my lord, this is Memorandum of Association, clause 62, my lord. I just wanted to.
But have you included?
It's in my rejoinder also. It is there in my rejoinder.
It is there in the rejoinder, my lord, but that rejoinder was.
Yes, I think this is also not disputed.
Hello, this is with regard to the appointment, my lord, of the directors, my lord, directors, chairman, etc., my lord, and MD. My lord, the government clause 61 and then 62, my lord. My lord has got it.
Yes, yes.
The governor shall from time to time determine the number of directors of the company, which shall not be less than 2 but not more than 14. The directors shall not be required to hold any qualification shares. So these are the things. Then we come to 62, my lord, clause 62. So here is the, which covers the appointment of chairman, MD and other directors, my lord.
I think Mr. Bhattacharya will continue. Continue next date.
My lord.
Heard Mr. P. Bhattacharya, narrated, also to respondent. Hearing will continue on next date. This is matter to 3 weeks.
Item number 13.
Single bench will sit again after DV. Because
Second
after
DV.
lunch we'll sit in DV.
DV, yes, my lord.
And whatever matters that are remaining. Otherwise, if parties are inclined to make mention.
14 will take some time, Lord. Item 14, that the cancellation of.
Okay. Only item 14 is left. So we'll take, when do we take it?
Lord, because that matter will take at least half an hour from 30-40 minutes argument from my side.
Because we have DB now.
Yes,
tomorrow?
Lord. So, day after tomorrow, Your Lordship may have it day after tomorrow. Tomorrow is day after tomorrow.
On pre-made by Mr. License matter on.
Why not 20th? Day after tomorrow is 20th.
20, madam.
20th.
The item number
Published, my lord.
13 is the next item, my lord, which has been called out. So this pertains to a salary matter. Actually, this is little urgent, but this matter connects to the other item number 9, 10. So my lord has fixed that for hearing. So if this matter, item number 13 also will be taken along with the other matters.
Okay.
Next.
So 13 along with 9 and 10.
9, 10, 11.
9, 10 and 11, my lord. Much obliged.
The other matters we'll take up after sitting of the
Division.
Or yes, Mr. Sinkon? Is there any lengthy hearing involved?
Hearing, my lord, require a bit of time, my lord, not much.
So we'll take it up after
Once I sit, huh?
after DB sits. I mean after DB rise.
Yes, Your Lordship,
Now-
it would be proper because the counsel for the same would be in a proper position to advise this court to give our proper
Or both parties are here.
Yes. It was here just a while back, Your Lordship.
It's already been informed.
We'll take it up after.
Any mention?
My lord, I beg to mention item number 14, my lord. My lord, this is a legal aid matter. I have received the paper book, my lord. But I was going through the paper book, it is not complete, my lord. I may be allowed to go back to the registry again, my lord. 14.
That you can do if you want to. Since this is mentioned out, if you're asking for time, then time will be given to you.
My lord.
3 weeks.
18. My lord, there are two connected matters, item number 18 and item number 24, my lord. Now in 24, they are from the same judgment, my lord.
18 and
24, my lord. 18 is a private appeal, my lord, and 24 is a legal aid appeal, my lord. Both are connected from arising out of the same judgment, my lord.
I mean 24.
No, I'm not.
You are making submission in 24.
24, my lord.
But who's in 18?
18. Mr. Nath was appearing.
Is he here?
Yes, I'm here for the state allotted 18.
No, Mr. Nath. 24.
25 I'm there, man.
I'm
24.
seeking some 24, my lord.
4 weeks.
Deeply obliged. Listed.
18 we cannot pass on.
They may be listed together, my lord.
Yes, we just note on the margin. 18. Just write 18. So 18, 24 and 18 will be connected.
My lord, item number 18, I'm the appellant.
Oh, you're there?
Yes.
Then 18, 24, 4 weeks.
Much obliged.
May I please, Your Lordship? I beg to mention item number 10. This is a criminal appeal, Your Lordship. Last occasion we have already filed our paper books. So today, like learned conducting counsel is indisposed. So I humbly pray this matter be fixed after 3 weeks.
4 weeks.
Deeply obliged.
Okay. Yes.
Lordship, I beg to mention item number 25. We have already prepared and filed a paper book, Your Lordship. I pray 3 weeks time, Your Lordship.
4 weeks.
Yeah, please, Your Lordship. I beg to mention item number 15 and 16. Minute.
Item number?
15 and 16. Minute.
15, 16?
Yes, ma'am.
4 weeks.
My lord, item number 26 also, I'm seeking some more time.
26? Okay.
4 weeks, 26.
My lord, item number 12, my lord. Item number 12. Here I am for respondent number 4, my lord, so I'm seeking some time.
I have the objection regarding this. This matter has been pending for 9 months, Your Lordship. And due to this, the villagers has been suffering as the acting
Is that
headman.
election matter?
Yes, Lordship.
With a short.
Moplang election?
Yes, election of headman of Mangap Krishna.
Yes, why you're, I think last time so this court has indicated that, you cannot take a judgment in this matter. You're a
Petitioner. For petitioner.
This is daily. Yes, what do you say?
Your Lordship.
You have any objection to their
No, Your Lordship.
respondent?
There's too
You
much
are-
DD,
who are you?
Your Lordship. There's too much DD in
Who are
this
you?
case. I'm for respondent 5, CL Mauplang.
Same.
CL Mauplang. Yes. Respondent number 5.
Your respondent number?
4, my lord.
Oh.
Yes.
Who's the incumbent?
I can.
There's no. Nora must know as of today. There must be somebody.
I don't have. I don't have. Your Lordship, the acting headman, he is under the authority of preference of respondent number 4. That's the delay in this appeal is to allow the acting headman to let the villagers under his control, who is now abusing his power. Your Lordship, the villagers are suffering because he is abusing his power. There's a biasness against some of the villagers who is not in his favor, as some of the villagers want a fresh election on this.
We'll hear this matter next week. Next week. We'll take up this matter on 3rd. No more adjournment.
On 3rd. Okay.
Ms. Larrett, counsel for the respondent number 4, has sought for accommodation on grounds of personal difficulty. Next. Ms. Larrett, counsel for the respondent 5, has submitted that this matter has been delayed for quite some time. As such, it is prayed that
last chance be given.
Last chance be given. Miss Larrett, counsel appearing for the appellant, has no objection to the prayer for adjournment. Next, on consideration of the submission bill, we are inclined to allow the prayer of the respondent 4. However, it is made clear that no further adjournment will be allowed in this matter. This is matter of the 2 weeks. Because next week is a holiday.
Yes,
2 weeks.
really obliged.
Please, Your Lordship, I beg to make a mention of item number 17. 17. 17.
Mr. Yobin.
4 weeks.
Lordship, similar matter, similar prayer for item number 22.
22.
Four weeks.
Much obliged, Lordship.
Please, Your Lordship. I beg to mention item number 20 and 21, Your Lordship. Due to my ill health, Your Lordship, I could not prepare for hearing. So I'm praying for 3 weeks' time, Your Lordship. 20 and 21.
It's okay. We are there. On grounds of personal difficulty, Learned Legal Aid Council has sought for accommodation in this matter. Accordingly, as prayed for, release this matter after 4 weeks. 2021. Yes.
Please, Your Lordship. Your Lordship, I beg to mention item 8. The conducting council is out of session.
Four weeks.
Much obliged, Lordship.
Back to mention item number 9 on joint request, Lordship.
Yes, Your Honor.
After 2 weeks.
Joint request, yes, sir.
3 weeks.
I mean, the board is very full. Therefore, we have to, put it after 3 weeks or 4 weeks.
Oh, yes, Your Lordship.
3 weeks.
I'll oblige, Your Lordship.
From the list, item number 1.
Yes.
Please, Your Lordship. In this case, my lord, regarding the explanation of PW3, in this PW3, the then defense counsel.
What are the?
It is judgment received.
This matter has been heard, Mr. Thini.
In this case, my lord, the fact remains that the exhibit in page 34.
This matter has been heard.
Lordship, if I may, my lord, actually the prosecution has started with the argument, but on reaching the deposition of PW3 at page 34 of the paper book, my lord, it has been noticed that the cross-examination was reserved.
Okay.
My lord, that is the matter, my lord.
As a matter of fact, it has been heard entirely from my side long time back. I think more than 1 year.
What is your submission as far as?
My submission, my lord, is that this eventually PW3, his deposition has no evidentiary value as far as he has not indicated that regarding the kill of the accused. Again, because Ibar Chulet is a brother of Lobby Chulet, but the fact remains that he is a social witness. That is the most important thing, the social witness. And he is a social witness, then then it was not refixed nor doing anything. Then they have skipped over straight away to the another witness and ultimately closed and ultimately decided in the lower court, in the court of first instance by district judge. It has been heard and decided.
So according to you,
according to me,
you are not prejudiced by the evidence of this witness.
Yeah, it has not affected my. It does not in any way prejudice me. It does not in any way prejudice me because he has not stated anything that he is that he has seen the thing. He has no value at all. Ebersulet has no statement has no value at all. And the same thing also that PW4 has been dropped. He is also a social witness. Same thing like Ebersulet. So even if he is dropped also, my lord, it does not make any difference. Even if he is dropped also, he has no difference. Suppose if we don't cross also, it makes no difference. So in view of that, my lord, it does not affect in any way my case. Okay. My case. And this matter has been heard long time back, and almost 3 years since it was last heard. It is the same subject matter, and that is the only thing pending as far as this case is concerned. That was received. Otherwise, it has no evidentiary value. So there's no harm if you drop him also.
Okay. Prosecution has not been heard in this matter.
My lord, it was heard up to this stage, my lord, and then when it was noticed by this honourable court that PW3 was not cross-examined, but nevertheless his deposition was taken into account while during the judgment portion. So the question arose from this court whether it would be detrimental to the appellant or not if he was not cross-examined, to which my senior has answered that PW3's deposition is of no evidentiary value. So, my lord, that can be actually the submission can be recorded, my lord, at this stage. I was prepared for argument today because I had already presented a judgment for this before this honorable court, my lord. So, but since my senior has conceded that we can proceed with this matter, my lord, I think there is paucity of time because there are 3 connected cases, my lord. So, I will not be able to complete today, lordship.
But like tarik mo, like tarik mo case. We'll have it on the 3rd then.
My lord. But my lord, kindly, if the submission can be recorded, my lord. That's my prayer of the senior counsel, my lord.
That will be taken
yes.
note of.
Yes. Much obliged, lordship.
On premade parties, this is matter on 3rd.
Item number 5.
Here in this case, lordship, I have filed one miscase raising the issue of juvenility. Apart from that miscase, lordship, I have filed an application for suspension of sentence, lordship. In my face, I have a document, birth certificate, lordship, and birth certificate was obtained prior to the incident, lordship. The incident was happened in 2014, lordship. And that time I was below 18, lordship. And neither the prosecution nor the defense counsel has brought this issue before the learned trial court, lordship. And the sentence has been passed, lordship, that life imprisonment for an offence of 364A, lordship. So, my lord, if the matter may be today was within this week, lordship, if any day, lordship, or immediately after the vacation, lordship.
2 weeks.
Because birth certificate is the lordship.
2 weeks then.
Lordship.
Item number 23. Supplementary, this item number 1.
This is not really essential religious prayer. It is up to that particular religion whether it is essential or not essential, my lord. Now, as far as guarantee under Article 25-26, my lord, it covers even to the modes of worship. How the worship will be done, my lord, how the in what manner it will be done, who will do the rituals. It is up to that particular religion, and the guarantee of Article 25-26, my lord, it covers to that extent, my lord.
Yes.
It includes all. Now, as far as the coming back to the present case, my lord, the rituals which is to be conducted in two sacred places, my lord, that is Maunaran and Leisilong, my lord. As far as Niyam Khasi is concerned, these are very vital rituals, my lord, that has to be performed in these two places at Millim, my lord. Now, these are very much essential for this particular religion, my lord, because this is their identity. This is their religious and spiritual identity, my lord, and conscience of that particular religion, my lord. And therefore, this if this particular religious practices, my lord, if these are to be removed from this, as far as this posts are concerned, now here it is concerned, these rituals are to be performed by the Lingdo as well as the Mantri Sankur Khadmi. Now, this, as far as my main case is concerned, my lord, I have prayed for the removal of these mantris because they do not anymore belong to that particular religion. They have changed in they have done change in their faith, my lord, and therefore they are no more eligible to hold those posts.
Nothing
because
has been
they
decided on that, my lord.
Of course, my lord, of course.
Nothing has been decided.
Of course, the matter is pending. That is still sub judice. Now, while making a prayer, my lord, in that line. Here my prayer is, my lord, because of their conversion to other faith, my lord, now they are no more capable or eligible to perform these rituals. It will directly hit Article 25-26. And now these rituals, my lord, these cannot be separated from this post. These are attached to the post. Post, my lord, this is a creation of the religion itself, because they are the one who perform the religious duties as far as Niyam Khasi is concerned. Now, these posts also are the creation of religion itself, and therefore these practices which is attached with the post, it cannot be separated, my lord. And therefore, this is very much part and parcel of the religion of Niyam Khasi, my lord. And hence, as it is, my lord, that these are very much essential part and parcel of this particular religion, my lord. This cannot be separated, and hence my humble prayer, my lord, that tomorrow's rituals, which is scheduled on the 19th, my lord, these cannot be allowed, my lord, to be performed by the people who do not have faith in it, my lord, and it will directly violate Article 25, 26, 29, my lord, and these rituals, as far as this ritual is concerned, this can be performed in the month of May. So we are still in the month of May. We have some more days. But for tomorrow, my lord, my humble prayer is that direction may be given to the respondent not to go ahead with the rituals for tomorrow, which is scheduled for tomorrow, my lord. And there is every possibility there may be also law and order situation, my lord, which I have come across, my lord. And it cannot be, my lord. My lord may kindly see this. If this analogy is applied, this will be otherwise applicable to every religion, my lord.
What is the precedent of earlier practices?
Earlier practice, what has happened in the last occasion, my lord, when we filed the case, then because of the interference by the court, my lord, the religious practices, rituals were allowed to be done by representative of the Sankur. So not by this mantri, but it was performed through representative of the of those 5 clans.
But the same
religious practice.
You have that order,
my lord. It was done, my lord. My lord can.
You should have annexed that.
Yes.
If there's a precedent, then
yes, my lord.
That precedent.
My lord.
That's a precedent, my lord.
Yes.
For years altogether.
It was done, my lord.
It
was done, my lord. What has happened is that there was no direct order by the court, but because of interference by this court, it was allowed to be performed through representative.
My lord, that will depend on the clan, my lord.
Yes.
That particular order.
My lord, one order.
That particular order that the court will allow the performance of the ritual.
No.
Well, there is only one order, my lord. That is 21/5/2025.
The only thing the court has said is that it should not be stopped. We have not stopped it.
My lord, and
This
it was
have to
performed.
continue.
It was
It was
performed.
performed.
It
And
was
today
performed.
is all. Tomorrow is already scheduled, my lord.
It
They
is
are aware
scheduled,
of
my
it,
lord, but
Mr. You have not answered.
My lord.
When I see what are cite examples of precedent, past practices, whether each and every time this is it an annual ritual?
Annual ritual, my lord.
So let's go back at least to 2025.
Yes.
Or 2024, when such ritual was carried out. Who has done it?
Yes. Now, my lord,
whether it was done by ministries who profess
Sankur and Levin.
Earlier, my
Christian
lord,
faith, or whether it was done by those who are of the indigenous
yes, faith. My lord, as far as if we go back earlier, my lord, it was all performed by the Niyamkhasi people because they have not converted. But subsequently, my lord, subsequently, because of conversion, my lord, probably some of them were still in Niyamkhasi, some of them were Christians, my lord. Nevertheless, my lord, it was performed. But now, people, my lord, they are conscious about their rights. They because it is the violation of their fundamental rights which is guaranteed by the Constitution. Now they have come forward before this court, my lord.
That's a different thing.
That
Yes, issue
right.
has not been decided.
Yes, and as far as last year, my lord can have a can record my submission that due to interference by the court, the religious rituals were performed by the representative of the Sankur Khadveikur, my lord.
Who are of indigenous
who belong to the indigenous faith.
That's what I want. I want that order. You said
My lord, there
interference
was-
by the court. No,
My lord, what
no,
happened
court
is
will
that there
interfere.
was a-
How will the court interfere? In the form of an order?
My lord, if I can read out the first order,
The only
21-5.
only last year, my lord, what happens that
Let him.
Yes. No, there is one order, my lord, 21-5-2025. It says, my lord, hard so and so, and so and so,
Which
so and
case?
so is present.
This case?
Yes, pertaining to this case only, my lord. It says, my lord, accept notice on behalf of respondent number 15 so and so, and no further notice is called for. 21-5-2025, my lord.
This is
183.
This is 2026 case.
No, 183. This the main case, Kirsan Marbani. WPC 183 of 2025.
So you are making a submission in this 183 or in this?
My lord, I am making my submission in 183, miss case where I have filed a miss case, my lord, in 183.
You filed in 183?
Yes, my lord.
What is that order, Mr. Sankar?
That order is 21-5-2025, my lord. Now, this is probably the first order, my lord. It says,
Yes, sir.
yes.
Twenty-one.
21-5-2025, my lord.
There's no order. Oh, just one.
In WPC 183 of 2025.
Yes. Please.
First order, if I'm not wrong, my lord.
Please
And
read out the order.
the third paragraph, it says, my lord, as the matter seems to be of some urgency, the petitioner is permitted in the course of the day to effect personal service upon so and so, so and so. The grievance of the writ petitioner, who is stated to be the Lingdo of Raid Milim, is that the upcoming religious event, that is Kalenium Raid Milim, which is scheduled to be performed on such and such date, is sought to be stopped by the respondent number 8, who is stated to be Mantri of Hima Milim. So and so has also submitted that the matter appears to be of extreme urgency and that the same may be taken up tomorrow. So and so has submitted that the petitioner is also fearful he might be removed from his post. Accordingly, it is directed no coercive action shall be taken by the concerned respondent. Now, my lord, may kindly come to page number, order number 23, order dated 23-5-2025.
23 or 22?
23-5-2025.
There's no 23.
There is, my lord, one 23-5-2025.
In this case?
In this case only.
Next, because next order is 22-5. Very elaborate order.
I think probably that is the order, my lord.
So
In my
23, yes.
23, my lord. If my lord has the order.
Yes, 23. What does it say?
I'll just read out the order, my lord. That will be because it is indeed unfortunate that the petitioner number 1, who is the lingdo of Right William Simsip, together with the petitioner number 2, a member of Nongklau clan, has to knock upon the door of the court to seek relief and direction for the holding of age-old rituals of the resident of Milim belonging to Khasi indigenous faith, which has been practiced since time immemorial. The ritual in question is the Kalyanium Right Milim, which is held annually in the month of May, which has great religious significance for Right Milim. The said religious rituals as per record is held in 2 parts, at Maunaren and at Leisilong. As per custom, petitioner number 1, who is the prime religious functionary, is responsible to discharge the important duty to make all preparations which are necessary for the rituals, meaning the article that are to be used apart from the offering and other instrument. The other constituent, which include the members of the respondent number 4, who are the members of the Mantris of 11 Kur or clan of Right Milim, also have an important role to play in holding this event, and from amongst these clan are the Lingskor from the Sotun clan and the Mentri of Nongklau Ringi clan. As per custom, before these rituals are held, a Dorbar is convened by the Lingskor to discuss this religious event of the Right Milim and to fix dates for the same. It is the case of the petitioner that such Dorbar has been fixed on 14/4/2025 in the office of respondent number 3, and that in the said meeting the constituents of respondent number 4 had informed that the religious performance would not be held and that the same would be decided in the next meeting of the Dorbar on 25/4/2025 to be held at Yomilim Rim as per practice. However, in the said Dorbar on 25/4/2025, where the petitioner number 1 attended, besides members of the public belonging to the indigenous faith, as the same was of great importance, before any final decisions would be arrived at, and altercations broke out between respondent number 8 and a member of Nongklau clan, which resulted in an FIR dated so and so being filed against respondent number 8 for his case. In the above noted backdrop, the all important issues, that is holding of the religious ceremony of Right Milim, could not be resolved, as it was imperative that the said customary religious ceremony be held in the month of May itself. The petitioner number 1, as the priest and the lingdo, had proposed 24th May 2025 to 29th May 2025 as the dates for holding the said event. Thereafter, it appears from the material as placed, the Lingskor of the Right Milim was mentioned, was petitioned by the petitioner number 1 and by the public by letter dated so and so that the annual ritual ceremony be allowed to be conducted on the scheduled dates, which however it appears met with no response and resulted in the matter coming before this court. This court, on the matter being moved on 11th hours and considering the short time available, had directed for notice to be issued immediately and to try and resolve the issue, as it had been submitted that it was unnecessary that the members of respondent number 4 and the petitioner number 1 meet to decide on the issue. Then by order dated, which is reproduced herein below, had directed as follows. So this is the order, my lord. Today, I'll just read because it is important also, my lord. Today, Mr. T.T. Dingdo, so-and-so, senior counsel assisted by so-and-so, that is not important, my lord. Extra copies, petition number, paragraph number 3, the petitioner number 1, who is stated to be the lingdo of Right Milim, and the petitioner number 2, who is stated to be an interested persons, are before this court with a prayer that the Lanium Right Milim, which is customary rituals and as per submission scheduled to be performed on 24/5/2025 at Maunaren and Lomshilong, be conducted as scheduled. The difficulty that has been projected before this court by the petitioner is that though a meeting was held to decide upon the dates by customary Dorbar consisting of the respondent number 4, also the same could not be achieved due to a dispute between the respondent number 1 and the petitioner, which resulted in an FIR dated so and so. It is submitted that as it is very important customary rituals that has been performed since time immemorial, the same should not be disrupted and should be allowed to continue on the date so fixed. From the side of the respondent, Mr. So-and-so, so-and-so, who is who is the Mantri Sankur Khadwekur of Himamilim, submits that it is not disputed that the holding of the rituals for Lanium, Raidmilim and Leshilong is the rituals that has to be performed annually, and has submitted that as per custom and practice, the Dorbar of Mantri of the Sankur Khadwekur together with petitioner number 1 and the other elders and headmen are to convene and decide on the same. He also submits that it is due to disruptions that had happened in the Dorbar on so and so that the dates could not be agreed upon. He further submits that as per customs also rituals has to be held in the month of May, and for that the Dorbar has to be convened to decide on the dates. The other respondent also do not dispute the submissions made by the counsel for the petitioner and respondent number 4. This court, on hearing the learned counsel for the petitioner and the respondent number 4, notes that it is a fact that Lanium Raidmilim has to be performed after Dorbar of Raidmilim has been convened, wherein the essential participants are the Lingdo and the Mantri Sankur Khadwekur to decide on the dates as they are essential for the performance of the rituals also. It is seen that in view of the disruptions that had happened, there is no clear picture as to a way forward except for the dates that has been proposed by the petitioner. Looking at the larger picture, and in view of the fact that the residents of Raidmilim who still follows the indigenous faith have been petitioned the Linkscore, as it has been made known to them that perhaps the rituals may not happen this year, a certain media has to be worked out by this court so that at least the community shall not feel that they have been deprived of essential rituals, which is the customary practice of the Raidmilim. On a query from this court, so-and-so submits that the time available is perhaps too short to have a proper Dorbar, but has however volunteered that an attempt can be made to get together the most important constituent of the Dorbar to at least come to some decision. This court also notes that the CM of Milim has an important role to play in as much as before the commencement of the rituals. Voluntary contributions are received in the office of CM Milim, which are used to defray the expenses that will be incurred in performance of the rituals. As it has been categorically submitted by the parties that the rituals cannot be conducted or held after May, and taking into account the sentiments of the community in the interest of justice, it is directed that the petitioner number 1 and respondent number 4 and 4 shall meet today itself as by convention in the office of the CM of Milim. The respondent number 8, represented by so-and-so learned counsel, has fairly submitted that respondent number 8 will ensure his cooperation to see that Dorbar is fruitful and rituals are carried out in a normal manner. Mr. So-and-so learned counsel, who is present on behalf of the CM of Milim, is directed to ensure that the CM of Milim deputes 2 mentorees to be as observer in the said Dorbar so that matters are conducted in a peaceful and cordial and lawful manner. Mr. So-and-so learned counsel, who is present on behalf of district council, has expressed his view that the matter should have been amicably and harmoniously conclusion so that greater populations are not affected. On the directions above, it is expected that immediate steps be taken by the learned counsel present to ensure the meeting today itself to fix the dates, since there is shortage of time to consider the dates proposed by the petitioner. List the matter tomorrow, so and so copy of this order be given. Now paragraph 6, it says this court thereafter was hopeful and in anticipation that the members of the respondent number 4 and respondent number 8 would facilitate the conduct of the religious rituals, considering its importance and the meaning it had for the public, and that the Dorbar would have a positive outcome. However, when the matter was taken up today, the counsel for the respondent number 4 produced a report of the Dorbar held on so and so as per the directions of this court, wherein it was recorded that though they respect the importance of the rituals and that the same should be conducted as per the prevailing custom and traditions due to requirements that had to be fulfilled before such rituals, the contribution to be received from Kurkalang clan and the holding of proper Dorbar, it was conveyed that the rituals for this year be abandoned and that the same be conducted in the following year. Mr. So-and-so learned counsel for the petitioner has submitted that when all the members were present, and it being a duty of the petitioner number 1 to make all the necessary arrangement as per custom, for which all arrangements have been made, the decision to not allow the rituals to be performed will have a far-reaching and depressing effect on the people of Raidmilim professing the Niyam Khasi faith, as it will be a denial of their right to an important religious event which has been practiced since time immemorial. It is further submitted that as all preparations has been made, notwithstanding the fact that the mantris or members of respondent number 4 are unwilling to perform their customary duties, other members of this clan themselves are willing to perform the said duties. He therefore prays that for larger interest and religious sentiments of the public, the ritual schedule be allowed to take place. Mr. So-and-so learned counsel on behalf of respondent number 4 has also submitted that he had made all efforts to convince the members of respondent number 4 and also as to purport of this court's order in directions for a Darbar to be held decided on the matter. He has, however, expressed his helplessness in view of the stand taken by the members of the respondent. Mr. So-and-so, Senior Counsel, Learned Counsel, on behalf of the respondent District Council, has submitted that, taking into account the religious significance of the events which is held annually and considering the religious sentiments of the public who would be affected, it would be in the interest of justice if directions are issued for the rituals to be held on the dates proposed and scheduled by the petitioner number 1. On behalf of so-and-so, has submitted that as per directions of this court, the Darbar has held in the office of the respondent number Darbar was held in the office of respondent number 3 and 2 mantris observer were also deputed for the same. Mr. Khazan, Learned Counsel for the respondent number 8, has also submitted that the respondent number 8 also had cooperated and that he had expressed that any decisions was to be arrived at together by members of the respondent number 4 and the Darbar Right Malim. This court, on hearing the parties and in consideration of the facts and circumstances of the case, specially taking into account the sensitivity and sentiments involved, in order to bring about an amicable solution, had by the order dated directed for the Darbar to be convened in order to enable the performance of religious rituals which are intrinsic and important. But however, the same did not yield the desired result, as a perusal of the minutes of the Darbar dated so-and-so held at so-and-so in the office of respondent number 3, as had been produced by Learned Counsel, in fact reflect that apart from expressing the difficulties and obstacles in holding the rituals, no constructive suggestions were given by the members respondent number 4 to facilitate the same, which is strange considering the importance of the events for residents of Right Malim. This court has also noted that the matter was to receive due consideration by the respondent number 4 and its members' well-being well before the scheduled dates. But as it can be seen from the events of the Darbar held on so-and-so, due to personal difference which even resulted in FIR being filed, the greater importance of the public of Right Malim had been overlooked by its supposed guardians, resulting in the deprivation and trampling of the customary rights and practices of the public. This being the situation, considering the compelling circumstance, this court, in consideration of the customary rights, practice, religious rights and sentiments, and that the rituals have to be completed in the month of May itself, is constrained therefore to issue the following direction to ensure the performance of ritual as scheduled, even if the same be token in nature. As suggested by the petitioner number 1, the name of person belonging to respective clan who are to participate in the ritual shall be submitted to the office of respondent number 3 for acknowledgement, which however will also not bar the members of the respondent number 4 taking part in the same if they so choose to ensure the peaceful performance of the rituals. Keeping in view the situation, the respondent number 5 and 6 shall ensure adequate security being put in place. As these rituals have been allowed to be performed on the scheduled dates by this court, it is expected that the members of respondent number 4 cooperate in the same in the larger interest and common good of Right Malim and its populace. Now, in Roman, my lord, that is Roman 1, that is the direction, my lord, where we were directed to give the names to the names of those representative of those 5 clans, my lord, who will perform those rituals, and we submitted the names, my lord, and thereafter rituals were conducted. My lord, similar way, my lord, even for this time, till the time, my lord, this matter is finally decided, we want that the scheduled dates, my lord, tomorrow, we want that may kindly be stayed, because we do not, my lord, this cannot be allowed to be performed by a person who does not have faith in it, my lord. And my lord, this will desecrate the secret place that is of the Niyam Khasi, my lord. And also, my lord, this is the religious sanctity also. And in consideration of, my lord, the last order also, my humble prayer, my lord, it may be till tomorrow, because the matter may kindly be fixed tomorrow before the regular bench, my lord, who were taking the matter. But for today, my lord, may kindly give the stay, my lord, on that performing the rituals. If they are anyway agreed, let them come before the court tomorrow, my lord. The matter is anyway coming fixed tomorrow. My lord, let it be fixed tomorrow, my lord.
My lord, what is the case of my friend here is that on the last occasion a decision was taken not to hold it.
My lord,
we are holding
no, that is incorrect, my lord. My lord, that is incorrect. What was the situation in the earlier time, my lord, earlier year, last year, my lord? What was the situation? They do not want to perform those rituals, my lord. Therefore, and it was informed to us that they are not going to hold. They are not going to hold and perform those rituals, my lord. And I can fairly understand the difficulty for them also, being from a different background. Now, As far as, my lord,
you see, Mr. Kunkan, you have read the order. The order is in a different context.
Yes, my lord, it is on the same ground.
See, maybe.
Yes.
Maybe for the same reason.
Yes.
That whether the ritual is to be held or not.
No, that is incorrect, my lord.
See, that order did not specifically differentiate.
My lord,
it did not specify as to who is supposed to conduct.
Yes, my lord. The main.
It did say that it has to be conducted.
Yes.
Because that is the.
My lord,
that is the custom. That is the ritual. Right. True.
Yes.
Anyway, that's beside the point.
My lord, the last page of the order, my lord, the court made it very clear. If I can just point it out again, my lord. It starts from paragraph 14, my lord. It says, these being the situations and considering the compelling circumstance, this court, in consideration of the customary rights, practice, and religious rights and sentiments, and that the rituals have to be completed in the month of May itself, is constrained therefore to issue the following direction to ensure the performance of the rituals as scheduled, even if the same to be token in nature. First direction, as suggested by the petitioner number 1. What I suggested is, my lord, that let the rituals be performed by the representative of this Sankur Khadweikur, my lord. And as per my request, my lord, what the court said, my lord, as per my suggestion, it says, as suggested by the petitioner number 1, the name of person belonging to respective clan who are to participate in the rituals shall be submitted to the office of respondent number 3. That is same, my lord.
Well, also not
for
bar.
acknowledgement. For acknowledgement. Now, after I have submitted those names, my lord, the names, and we were allowed to perform those rituals. We have concluded the rituals. Now, one small question, my lord, even to my learned senior also, that whether it is not a violation of fundamental rights. We are all here, my lord, to protect the rights of the citizen. Even this court, my lord, is constituted for protection of this fundamental rights.
He will read the entire paragraph.
It cannot be, my lord. It cannot
Let him
be.
read the entire
My
paragraph.
lord, I will read. It says, my lord, which however will also not bar the members of the respondent number 4 taking part in the same if they so choose to.
Who are the respondent
now,
number 4? Is the clan.
Of course. Now here, my lord, here my submission is, my lord, whether a person who do not have faith in that particular, who do not belong to that particular religion, whether he can come and do those rituals for that other religion. That is first question, my lord.
Your point has been noted.
Right, my lord.
Yes. Only one thing, my lord. My friend, maybe he's not aware. Maybe his client has not given him clear instruction, my lord. The petitioner in this case, my lord, was present in the minutes of the meeting which was held before. That I think
I am enclosed. And my lord, just very humbly, my lord, I will just make one small submission before my learned senior says so. Because this representation which has been produced before the court in another proceeding, my lord, learned senior has, in a very different way, my lord, has impressed upon the court that the matter has been resolved among themselves. That is absolutely incorrect.
That's what the meeting says, my lord.
I have enclosed the minutes of the meeting, my lord. May kindly have a look. That is absolutely wrong statement which was given, and it is a misleading statement from the learned senior, my lord. If my lord will go through the entire minutes, that is the attendance sheet, my lord, which has been signed. Absolutely wrong, my lord.
My lord, you are referring to which?
My lord,
may kindly come to.
I'll just give one copy of it.
My lord, I have in fact enclosed.
You have enclosed this?
Yes, my lord. I have enclosed as Annexure 5 series, my lord. Annexure 4, my lord. In nowhere, my lord, it says that the matter has been settled. However, learned senior has given such submission before the court.
My lord, we'll go to the entire minutes of the meeting.
Of course, my lord.
Page number 34. His signatures appears at serial number 14, my lord.
In the attendance sheet, my lord. My lord, may kindly have a look at the attendance sheet. What does it say on top, my lord?
Where is
page number 38? Page number 38, my lord. It says, my lord, attendance sheet, my lord, it is clearly written. Does it mean that just because I have signed the attendance sheet, my lord, I have consented to everything what was written in the resolution? We are not part of the minutes of the meeting, my lord.
Minutes of the meeting
we are not part of it, my lord. It is recorded by them. Our signature is nowhere there.
Yes,
and in
of
fact,
course, my lord.
Nowhere it says in the minutes also that matter has been resolved.
Serial number 14.
Where is your name? Where is?
Serial number 14, my lord. Serial number 14, my lord.
Page number 39, my lord.
Page 38.
39. Page number 39.
38 and 39.
39, my lord.
What about 38 and
38 also, my lord? These are all attendance at continuation, my lord.
Continuation.
Initially, my lord, till page number serial number 10 it was printed. However, they have written down while putting their signature.
From 18 it comes to 11 again.
Yes, my lord, it is because they have initially printed till 10, and next page started from 11, but they have continued actually their signatures.
You should have made correction anyway.
Yes.
14, my lord.
Page
That's
number,
his signature.
Paragraph, page number 39, page number 14. My lord, absolutely
issue,
a
my lord.
misleading statement was made before the
Absolutely
learned
not,
single judge, my lord.
Absolutely not, my
And
lord.
my lord,
Copy was handed over to the court, my lord.
without even giving a translated copy of the
My lord,
same,
I think,
and before filing, it should be brought on record by way of affidavit. Just simply submitting like this without translation copy, does it amount to, my lord,
that has been
record of the court?
My lord, that has been pointed out to the court
It
also,
should be
my lord.
given beforehand, my lord, to the
How can I
counsel
give?
also.
How can I
This
give
is
it beforehand,
on
my lord?
8th May, my lord.
Notice
This
was not even
notice
issued.
of 8th May.
Notice has not been issued to me.
They have
also.
not given this copy.
Okay. So what is your?
My lord, the entire matter is fixed tomorrow, my lord. If your lordship kindly see, this matter has been fixed tomorrow. Let it come tomorrow, my lord.
My lord, let it come. I have no issue, my lord. Let both the matter be fixed tomorrow, my lord. But till that time, my lord, till tomorrow, my lord, let there be a stay, my lord.
I have strong objection to that. my lord. He
let
has already.
his objection may be recorded, my lord.
Complaint
but
has
my
been
submission
filed.
is, my lord.
Complaint has been filed to me, my lord. They appeared before me, both the petitioners,
Of
in
course,
both cases.
I have to appear, my lord.
Minutes have been submitted by me
Let
before
my-
this honorable court on the last occasion. That's why that order has been passed. Yeah,
My
I
lord-
mean, my lord, if your lordship kindly allow me, the court even suggested the petitioner that he should withdraw the petition.
Of course not, my lord. I don't agree.
Yes, my lord will
My
see.
lord,
That
may
I
kindly-
can. Then
my
we will have to take the proceeding,
my lord- my
video
lord-
proceeding, my lord, if that's the case.
My
If he's
lord may
making
kindly
that kind of
see-
submission,
my lord may kindly
then
see
we
the
will
recording.
see the
It
recording
says
of the
the matter has been resolved. My lord may kindly see in which paragraph it is written resolved.
Yes.
Let my learned
Yes.
senior point out, my lord.
Yes. See the last
Yeah,
paragraph.
where
See
is
the
it
last
written?
paragraph.
Resolve as
It's
in
absolutely misleading statement, my lord.
Resolve as in
The complaint.
Which way?
My lord, what my lord learned senior has said before the court, the matter issue has been settled
See,
between
now,
parties.
You say that your main grievance,
my lord,
raised in this petition.
He has not raised any grievances, my lord.
Whatever.
Before the
What
same.
is your prayer?
Nothing,
Whatever
my lord.
My lord,
Nothing.
in my prayer is
He has not even uttered a word, my lord.
My lord, my case is already pending from before. I have filed a miss case, my lord, to stay the
whatever case may be.
rituals tomorrow.
Now, this is your prayer, page 12, isn't it? In your petition.
My lord, my prayer is, my lord.
Where is your main case?
Main case, my lord. Main case, my lord. I have the petition with me, my lord. I can read out the.
Page 16, paragraph 21, my lord.
If I can read, my lord.
This is your prayer.
Yes, my lord. If I can read, my lord. It says, my lord, in the circumstances stated herein above, Honorable Court may be pleased to issue rule calling upon the respondent to show cause as to why direction should not be given to the respondent to allow only the person belonging to Niyam Khasi Fate to hold the post of CM Lingdo Lingskor and Mantri of Himami Lim Simsep in terms of the custom, traditions and belief of Niyam Khasi, and also to enforce the law laid down by the Honorable Supreme Court in the case of Iwan Lanki Irimbai versus Jaintia Hills Autonomous District Council. And further be pleased to direct the Superintendent of Police is Khasi Hill District Shillong to provide adequate police personnel for the upcoming religious event of Kalyaniyam Ride Milim, which is scheduled on so and so at the holy place so and so, which is will help to avoid any untoward incident, and also to speed up the investigations of the FIR dated so and so through a superior officer in a time bound manner, and file the final report, and in the meantime restrain the respondent number 8 and the Mantri Sankor, Khadwaikor, Ringskor, etc. from discharging their duty as a Mantri Lingskor except for now here. And in the meantime, restrain the respondent number 8 and the Mantri Sankor, Khadwaikor, Lingskor, etc. from discharging their duty as a Mantri Lingskor except for religious duties as per the custom and traditions of the Niyam Khasi till the disposal of this instant case to avoid any conflict, and also be pleased to direct respondent number 4 for holding new elections for Mantri Sankor, Khadwaikor, Lingskor, etc. from amongst eligible clan belonging to Niyam Khasi Fate as it involves traditional institutions of same faith, and direct the respondent to not make any attempt to remove the petitioner number 1 from the post of Lingdo, and the grant stay against any such attempt of removal of thereof. Now let learned senior point out the paragraph where in the minutes of the meeting where it says that matter has been resolved amicably. Let learned senior point out.
My lord, we'll see the last paragraph.
Yes, kindly.
Yes, my lord.
What does it say? Page number 37, my lord.
Yes.
In Khasi,
Last
my lord will best understand.
Page 37 of the
Page
miscase.
37
Yes, ma'am.
of my miscase, my lord.
Just a moment, just a moment, Mr. 37.
Page 37.
Second last paragraph, my lord.
Yes.
My lord will go through. Need not read it also, my lord.
This doesn't say anything about.
Yes.
No, my lord. Excuse me. See, even here, this resolution,
No.
the question of who will perform the ritual is kept open.
My lord, by Sankur, but
the same said it's for the court to decide.
My lord. Yes, my lord.
My only
So, my lord,
humble
the-
submission,
the-
my only humble submission is, my lord.
Now it is for the members of the court
My lord.
who decide whether a Christian can perform the ritual or that is.
My lord. That will be decided by the court only, my lord. Then only if there's a bar, then only.
They
my
have
lord.
not decided.
Now
No, they have not decided, my lord. But resolution, the minutes clearly says that.
I think it's
My
proper.
contention is it is in violation of the fundamental rights, my lord. That I have already pointed out.
I think the ritual has to be stopped. At least for tomorrow.
My lord, I'm praying that matter may be taken up tomorrow, my lord. Let the court,
Yes,
my lord,
of course.
my lord,
Let it be
everything,
fixed tomorrow, I
all
have no
process has been done, my
So
lord.
it can be.
All carried out, my lord.
Even this court is also of the considered view that since the ritual has been fixed, it has to be carried out. But
My lord.
it has to be done properly.
Yes. And
Matter
we
has
have
not-
time, my lord.
Matter has not been
It
resolved.
has to be done in the month of
Matter has not been resolved.
My lord, they have.
Question is left open. So let that issue be settled.
Lordship, I am happy for the state, your Lordship. Lordship, can we have what is the grievances of the petitioner, your Lordship? If Lordship kindly have page 17.
Yes, that has been read out. The prayer has been read out.
Lordship, the issue is very important, your Lordship.
My lord, if that is the case, then my lord, the petitioner number 4 also will have to be, the Sankur Khadwekur also will have to be heard, my lord.
Lordship, kindly
They are the main
let them
concern,
come
my lord.
tomorrow, my lord.
I'm appearing for the same, my lord.
Of
They are not before your lordship. No, my lord.
My lord, we made an attempt to give the copy, my lord. They are not
Without
available.
them,
My lord,
If,
let it come up
kindly have
tomorrow.
Page 20 for the time being, paragraph 8, 9, 10, 11, 12.
And he is not representing Sankur Khandwekar, my
No,
lord.
I'm appearing for the same, my lord.
He is
my concern,
daily
yes.
represented, my lord. He cannot submit for the others.
He will be, you see, he is representing the same.
My lord.
The same is the elder.
My lord.
He is supposed to keep the peace.
Right.
He is not supposed to instigate
Yes, yes, my lord.
any conflict or confusion.
Right.
But perhaps now your grievance would be, basically against the respondent number.
Yes, we have made them
Your
partner.
respondent number.
There is a number 4 and respondent number 4.
4, my lord, basically 4.
They are not before your lordship also.
And notice has to go. My lord, they are already party. I have already informed them also today, my lord. But they said they cannot take it.
Let them serve the
Move
copy
it.
today. Let the matter come tomorrow.
No, my lord.
They will defend their action.
let-
I am here to defend my action. my
Learned
lord.
senior cannot submit for them, my lord.
That's what
Let
I'm
it
saying,
come
my
up.
lord.
Let it come up tomorrow. I have no issue till tomorrow, my lord.
I have strong objection to that, my lord.
That is my submission.
Page 20, your lordship. Paragraph 8, 9, 10, 11, 12, your lordship. You see, you are very sensitive, your lordship. Your lordship, especially paragraph 10, your lordship. Of page 20, your lordship. Very sensitive, your lordship.
Main petition
In the application filed by Mr. Silvan Klein, your lordship.
today. This miscase.
Page 20, your lordship. Page paragraph 10, your lordship.
Paragraph 10. Yes.
This is very sensitive, your lordship. Dena kan kata kapor belendiam ya kadok kenya ne jaknya apa dai ban nengkong do lendo ban bam nengkong do lendo bawa krau kata ki mentris akur kakui kur rei masosi kalau buan ki mentris san kakui kur ki wala klan yang kim ratio ban sip tetap ya bam lang kan very sensitive, your lordship.
They cannot do the rituals, my lord. That is.
Very sensitive. If this because this country has
The sanctity has to be protected, my
by a
lord.
non-Christian.
This is a guarantee of the constitution.
Well, let them serve a copy upon the respondent.
My lord,
number
that
4,
is,
the
he
matter
cannot,
can come.
my lord, learned
No,
senior
obviously, my lord.
cannot say anything about the other
No,
respondent.
my lord, I am here to defend. I am here to defend my
Of course,
my order. my
already
lord.
been defended.
Only thing is that they have to be there because they are the main
Of course,
parties,
we'll
my
make
lord.
them party. We already
They are the
made
main
them
parties,
party.
my lord.
We made an attempt also, my lord, to serve a
Without
copy.
them being serve a copy, without the hearing them,
Cannot
my lord,
make
whether
such
any
submission,
order
my
can be
lord.
passed,
He
my
has
lord.
been duly represented.
Respondent 4, no?
4, my lord.
4, my lord.
Only-
We'll make a copy, my lord. Give them a copy today.
Let the
itself.
matter come up tomorrow, my
Till
lord.
tomorrow, my
Let
lord. direction
everyone be
given.
heard, my lord.
At least till tomorrow, let
I
regular
have
court,
strong
my lord,
objection to
decide.
them. Without the parties who will
Let
be affected, my
Learned
lord,
Senior's objection be recorded.
they
my
will
lord.
be the direct
It's
party
a
who will be
simple,
affected.
basic question, my lord.
See,
Whether rituals can be
Mr.
performed.
See, Mr. Sinkod, you have made out. You have
My
made
lord,
out the case.
I have no more submission.
The court will give due credence
My lord.
to your submission.
Obliged. Obliged, my lord.
But the fact remains.
My lord.
You see, the person who may or will be affected
Direct affected.
by your submission is not here. There again, you see, basic principle of natural justice is
Of course, my lord. And my lord, therefore, my lord, 226, if my lord may kindly read the provision of 226.
Yes.
Yes. My lord, they can always file an application to vacate that order. Let them come up tomorrow with an application if my lord passes an order.
I've heard the parties.
They are always free. Obliged.
But why these two matters are being?
My lord, in one case, around 1500 people they have filed representation before the district council, my lord.
Same subject matter.
Same circumstance. They do not want that people who do not belong to that religion to perform that rituals.
There are two cases before me. This 183
and
for
197.
which you have filed this miscase.
That is 183, my lord.
Now another case is this 197.
197, if I can just simply say, no, it is his case, but it is regarding the public.
What is this? Is it connected to the?
My lord, this is connected because
That's the whole problem,
this is
my lord.
relating to the same rituals, my lord. Around 1500, I do not know exact figure, my lord. Around more than 1000 people, my lord, they have written a representation before the district council. That representation I have enclosed, my lord. Whereby they have requested that the rituals to be allowed to be performed by the representative, my lord, of the They then do not want the rituals to be performed by mantri who do not belong to the. Yes,
that
that's
is the
exactly on the same
address to
line.
me also.
Address
Same
of
complaint.
course.
Address to me also.
Yes, yes.
That's why there is
Nothing has been done. However.
Obviously, my lord, that minutes of the
Page 17
meeting
of
has
the
been.
application, your lordship. That is the representation, your lordship.
Okay.
The one which I have read, your lordship. Page 17, relevant page 20, relevant paragraph 8, 9, 10, 11, 12, your lordship. That is the representation of those people who have not converted, your lordship, to the district council, your lordship.
I'm obliged. Grateful.
It's the same complaint, my lord. Same complaint to this council as well as the same, my lord. I have convened the meeting and the minutes of the meeting has been enclosed, my lord. Obliged.
I thought the parties are positive.
Obliged.